Will Representative Colmenares kindly approach the podium?
Thank you, Your Honor. With the permission of the Honorable Court, members of the Honorable Court, Your Honors, we stand before you today to tackle a case which has resulted in one of the most widely supported TROs ever issued by this Honorable Court, restraining respondents from imposing on the people the largest increase in generation charge ever. The 4.15 peso hike consists of an increase of 2.38 pesos for the cost of electricity that was bought from the WESM. Then another 1.4 pesos from the supply of electricity from contracts of Meralco. The 70 cents are for taxes and subsidies. So of the total 3.44 peso generation charge, therefore, the cost of WESM-sourced electricity of 2.38 pesos is a staggering 70% of the entire generation charge. What makes this imposition, Your Honors, please, terribly unacceptable to our people is that the rate increase came about not because there was a substantial increase in the cost of producing electricity, but only because generation companies exploited the highly suspect simultaneous and scheduled and unscheduled shutdowns to make staggeringly high bids in the spot market called the WESM. Your Honors, our petition is quite simple. Respondent ERC committed grave abuse of discretion amounting to lack of jurisdiction when it hastily approved without a hearing and investigation the 4.15 rate hike imposed by Respondent Meralco and GenCos despite three highly irregular or unprecedented events which should have stayed its hands of approval as market abuse regulator. One, the rate hike is the largest electricity rate increase ever in the country. Second, Your Honors, the occurrence of simultaneous shutdowns of many plants, at least 6 plants scheduled shutdowns and 8 unscheduled shutdowns of plants which previously committed to producing power but strangely shut down at the time when their power was needed. This confluence of events alone should have compelled the ERC, Your Honors, to defer approval and conduct a hearing to investigate the unprecedented rate hike and any possible collusion to manipulate the market as any responsible market regulator would do. Third, Your Honors, Respondent Meralco, through its contracted energy with Thermamobile, made 62 peso bids in the WESM, the highest possible bid during the period of these simultaneous shutdowns, which not only increased the price of electricity that Respondent Meralco itself would buy from the WESM, but also the electricity bought by distribution utilities in other provinces. If only for this, Respondent ERC should not have merely stayed the approval of the increase, but should actually have disapproved it. Your Honors, Meralco, despite knowledge of the Malampaya shutdown at least more than a year before it occurred, refused to contract 100% of its entire energy requirement, which should have assured it of a stable supply of energy instead of being subject to the vagaries of WESM prices. In fact, while Meralco contracted 90% of its 7,000 megawatt energy needs with GenCos through power supply contracts, it has always bought 10% of its energy requirements through the WESM. One of these contracts is that which requires Thermamobile to supply Meralco with 100 megawatts at 8.65 pesos per kilowatt hour. Instead of accessing this 100 megawatts, considering its claimed lack of supply, Meralco ordered Thermamobile to sell 40 megawatts at the highest possible bid of 62 in at least 21 times, Your Honors, 21 instances, some even during peak hours when Respondent Meralco supposedly lacked supply. Because under WESM rules, the highest bid of electricity that was sold becomes the clearing price, which in turn becomes the price of the entire market. Meralco practically increased to 62 pesos the price of electricity it will buy through the WESM as generation charge. Respondent Meralco, Your Honors, please, then turns around and the ERC agrees to pass on to the consumers the very expensive generation charge it engendered, to the injury not only of its own consumers but also of consumers in other provinces. These acts of price manipulation, we contend, Your Honors, are antagonistic to the interest of Meralco customers and in violation of Meralco's duty under its franchise and the law to supply electricity in the least cost manner to its customers. Worse, it is now asking consumers to pay the increased price that Meralco itself created. The ERC, as market abuse regulator, should have at least taken stock of the situation first, conducted a hearing and investigation, instead of hastily and arbitrarily approving Meralco's letter after one working day, Your Honors, please. Were these events clearly irregular that disregarding these events voids the ERC approval of the rate hike? Petitioners contend in the affirmative, Your Honor. The fact that the DOE subsequently announced that it will prohibit bids in the amount higher than the contract price of said electricity shows that the 62 peso bid of Thermamobile in an amount incredibly higher than the 8 pesos contract price with Meralco only shows that this practice is highly abusive and wrong. The fact that even respondent ERC, although belatedly, lowered the price cap of WESM from 62 pesos to 32 pesos means that there is something irrational and anti-consumer in Meralco's bid of 62 pesos and that our allegations of highly irregular and wrongful acts are valid. Under Section 43D of IPIRA, Your Honors, respondent ERC has the duty to enforce rules and regulation governing the operations of the electricity spot market. ERC, Your Honors, dismally failed to fulfill its task and duty as market abuse regulator. The claim of ERC, together with other respondents, that unless automatically passed through, the GenCos will lose substantial amount, which in turn could affect energy supply as they have no funds to procure fuel and other variable costs. It is a blatant attempt, we believe, Your Honor, at misinformation to sway the public and this honorable court that it is to the best interest to set aside hearing petition and leave TRO because this allowing automatic adjustments will make electricity costly for the consumer. The substantial increase of 4 pesos and 15 cents in December was not brought about by a substantial increase in production cost, but was mainly brought about by the very high bids in the WESM by Meralco and GenCos intending to make a killing at the expense of the people. This simply means that the GenCos trading in the WESM produced the same amount of electricity at substantially the same production cost but at double the price. So if a GenCo was willing to sell its electricity for 5 pesos but sold the same electricity an hour later for 62 pesos, the increase does not in any way contribute to its cost of production. It just increased its profit. Your Honors, please, restraining payment of the additional 4 pesos 15 cents from the respondent payment for the respondent GenCos, even for several months, even for May or June, Your Honors, will not result in the incapacity to generate electricity as claimed by respondents. Restraining and eventually voiding the 4 peso 15 cents increase does not deprive the GenCos of money, but merely deprives them of windfall profits, exceedingly huge windfall profits. Respondent ERC uses the full and automatic pass-through provision related to generation charges for its inability to resist approving the rate increase. The policy basis for the pass-through provision is the claim of ERC and energy industry players that they will not be able to sustain operations if the rate adjustment for increases in the price of variables is subjected to hearings instead of automatically approved. This is the same argument they are using to ask the court to lift the TRO. It must be stressed that hearings and even the TRO will not result in bankruptcy because it does not threaten to deprive them of capital nor reasonable profit, but only windfall profit. Additionally, respondent ERC unwillingly admitted in Annex 6 of its own comment that in fact it is not true that full automatic pass-through is the only option for the country, as there are various methodologies around the world. To quote respondent ERC's Annex 6, distribution companies usually contend that power purchase costs are beyond their control. They argue that energy cost, often the most important item in their cost structure, should be full pass-through. In contrast, regulators are wary of automatic pass-through procedures which may lead to inefficient and sloppy buying practices, sweetheart deals, or even intentional overpayment of generators from distributors in return for a hidden kickback. From the ERC's own comment, Your Honors, please. In Brazil, even, Your Honor, there is only one adjustment every year. And yet the GenCos survived this policy because Brazil believes that constant adjustment will lead to hyperinflation. There is also, according to Annex 6 of ERC's comment, this benchmark set pass-through, where after a long careful study, the regulator, looking into the variables like currency adjustment, fuel cost, will set a peg of administratively set a benchmark, like say 4 pesos. And any amount of generation charged below 4 pesos is automatically passed through. However, once it goes beyond the 4 pesos, it requires a hearing before approval. So there are various ways of going about it, Your Honor, and it is not true. And the people will never understand respondent ERC's penchant to hastily and automatically approve rate hikes as if the energy sector will crumble if the same is not immediately granted, despite the fact that there are other methodologies of pass-through processes in many countries that are not automatic, but did not result in bankruptcy for the GenCos and the DUs. Your Honors, please, to sum up our argument, the ERC, in grave abuse of discretion, abandoned its role under the law and the Constitution as a market abuse regulator, and therefore its December 9 decision to approve the rate increase must be struck down. Your Honors, we will now discuss the constitutionality of Section 6 and 29, which prohibits regulation of the price charge for generation. Petitioners claim that these violate the Constitution because of our contention that the generation of electricity, a very important commodity, must be regulated like a public utility, and its generation charge cannot be perfunctorily passed through without granting the people the effective opportunity or process to be aware of it, and if they so decide, to oppose it. Article 6 of the Constitution provides that all economic agents should contribute to the common good, and the state shall promote distributive justice and, Your Honors, please, intervene when the common good so demands. Section 6 and Section 29 prohibits the state from intervening even if the common good so demands. Herein, because of Meralco and other DU's monopoly of the distribution, they are regulated. The same with the transmission. Question: generation companies are treated differently, even if they similarly remain an oligopoly too of major independent power producers, where 80% of the energy industry is controlled by about 4 or 5 or 6 companies or families. We contend that the generation companies' underpricing must be regulated and the automatic pass-through must be struck down. We contend that the generation companies are also monopolistic in character, similar with the distribution and transmission companies, and therefore must be regulated. Without regulation of GenCos, there is only one-sided, lopsided policy environment in favor of GenCos strive for profits to the detriment of the public. Absent market abuse, for example, Your Honors, the ERC could not have simply prohibited the sale of electricity at the obscene price of 62 pesos because it is proscribed from doing so by Section 6 and 29. Both sections virtually cut down the duty of the Constitution to intervene when the common good demands. Under Section 6 and 29, It renders the ERC, the state, and even this honorable court helpless in the face of excessive pricing and profit-taking by what could have been public utilities concerned primarily with the public service instead of profit. Your Honors, it has been 12 years since EPIRA was passed. It has failed to deliver its promise of lower rates for electricity. It is time, Your Honors, please, to turn off this experiment of the EPIRA. It is about time to ensure a brighter future for future generations that we turn off the lights on EPIRA, and we ask this honorable court to give its hand in turning off that light. Thank you.